Right now, the United States is fractured into two entirely different legal realities regarding the right to bear arms. In 25 states, citizens are being handcuffed and charged with felonies for carrying firearms without a government-issued permission slip, while across an invisible state line, their neighbors are doing the exact same thing perfectly legally under constitutional carry protocols. The Supreme Court has just docketed an emergency case that will either terminate this schizophrenic legal landscape permanently or entrench it for generations. Today, I am conducting a legal deep dive into 7 critical judicial inflection points that will determine whether you require state authorization to exercise your pre-existing Second Amendment rights. By the conclusion of this briefing, you will possess a precise understanding of the impending legal shifts, how they target your specific jurisdiction, and the immediate defensive maneuvers you must execute before these rulings are handed down. Here is the operational reality of why this is critical. A federal court has judicially declared the entire apparatus of firearm permitting unconstitutional. Consequently, 25 states have filed amicus briefs demanding nationwide abolition of permit regimes, and the Supreme Court has a 90-day window to respond. Understand the stakes. One incorrect assumption about your current legal status could result in $10,000 in immediate legal defense retainers and a permanent felony conviction. Number 1. A federal appellate court has issued a landmark ruling stating that requiring government permission prior to owning or carrying a firearm is a direct violation of the Constitution. This is not a peripheral judicial opinion. Here is the evidentiary basis. A gun owner in Texas lodged a constitutional challenge against the state's license to carry requirement, positing that necessitating government approval before exercising a fundamental constitutional right is inherently unconstitutional. The Fifth Circuit Court of Appeals agreed, issuing a decision that sent shockwaves through state attorney general offices nationwide. The court rigorously applied the Bruen test, the Supreme Court's 2022 standard mandating that current gun control statutes must align strictly with historical traditions from the founding era, specifically around 1791. The judicial audit revealed a stark historical reality. Between 1791 and 1900, not a single state in the Union required a permit to own or carry firearms. 0. The court examined legislative records from all original 13 colonies, plus every state admitted to the Union prior to the 20th century. Permit systems were non-existent. Even more legally damaging for proponents of permitting, the court found that when permit laws first emerged in the early 1900s, legislative records explicitly indicated they were engineered to disarm freed slaves and immigrant populations. The Fifth Circuit judicially labeled this a racially discriminatory origin story that cannot serve as justification for modern permit requirements. Here is the immediate legal hazard you must internalize. This ruling has generated instantaneous legal chaos. Currently, if you reside within the Fifth Circuit's jurisdiction, Texas, Louisiana, or Mississippi, federal constitutional law dictates you do not need a permit. However, state statutes still mandate one. This creates a lethal legal trap. You could be in full compliance with federal constitutional interpretation, yet still face arrest and prosecution under state law. This is not hypothetical. Last year, a Louisiana gun owner was arrested for carrying without a permit, despite explicitly citing the Fifth Circuit ruling during the encounter. He incurred $8,700 in non-recoverable legal fees before charges were eventually dismissed. That is financial damage inflicted by the state that he will never recoup. Here is your required immediate action plan. If you reside in a duty-to-permit state, do not assume this ruling provides you with immediate legal shield. Continue strict adherence to your state's current permit statutes until the Supreme Court issues final, binding guidance. Document every interaction with the licensing apparatus. Retain certified copies of all permit applications, denial letters, transaction receipts for fees paid, and logs of processing durations. This evidentiary paper trail could be critical if you are forced to litigate against your state's system in the future. But here is the terrifying reality that most gun owners fail to grasp. Number 2. Your Second Amendment rights are radically contingent upon which federal judicial circuit you physically occupy at any given moment. This is generating a profound constitutional crisis. Visualize this scenario. You are a law-abiding citizen with an impeccable background. You reside in Louisiana, where the Fifth Circuit has deemed permits unconstitutional. You legally carry without a permit daily. Subsequently, you cross state lines to visit family in New York, which falls under the Second Circuit's jurisdiction. The instant you cross that geographical boundary with your firearm, you are committing a felony offense punishable by up to 7 years in state prison. Same individual, same firearm, same clean record, but instantly transformed into a felon due to an invisible administrative line on a map. This phenomenon, known to legal scholars as a circuit split, is precisely what compels Supreme Court intervention. Currently, we face 4 contradictory constitutional standards governing the exact same right. The Fifth Circuit ruled all permit requirements unconstitutional. The Second Circuit upheld New York's draconian permit-to-purchase system. The Ninth Circuit validated California's may-issue regime, granting sheriffs total discretionary power. Meanwhile, the Fourth Circuit created an ambiguous intermediate test that defies clear legal interpretation. Here is the real-world fallout. Under current statutes, a Montana resident utilizing reciprocity agreements can legally carry in 38 states. However, if the Supreme Court rules that permits themselves are unconstitutional, the entire framework of reciprocity agreements could be rendered legally null. Conversely, if they uphold permits, Montana's constitutional carry status faces immediate legal challenge. Consider the plight of an Arizona truck driver recently arrested in New Jersey for possessing a handgun in his vehicle. In Arizona, this action is perfectly legal without a permit. In New Jersey, it triggers a mandatory minimum sentence of 42 months in prison. He is currently serving year 2 of that sentence, while his appeal languishes in the court system. Here is your defensive strategy. Never cross state lines with a firearm without conducting exhaustive research into the destination state's current penal code. Do not rely solely on reciprocity apps. They are frequently outdated regarding legislative shifts. Contact the state police non-emergency line in your destination state and pose specific legal inquiries regarding your status. Document that communication, including the names and badge numbers of officials providing information. Secure a multi-state carry permit from jurisdictions with broad reciprocity, such as Utah or Florida. Even if you reside in a constitutional carry state, these physical permits provide an essential layer of legal insulation during this transitional period of volatile legal change. And now we address the direct assault on your finances. Number 3. The Department of Justice has judicially compared permit fees to illegal poll taxes. If the Supreme Court adopts this reasoning, every firearm-related fee levied by your state could be declared unconstitutional. This is a potential legal bombshell. In 1966, the Supreme Court struck down poll taxes in Harper v. Virginia Board of Elections. Their legal reasoning was unequivocal. The state cannot monetize the exercise of a constitutional right. Voting is a right, not a privilege administered by the state. Therefore, the government cannot attach a price tag to its exercise. The DOJ's brief argues that the Second Amendment operates under identical constitutional constraints. If bearing arms is a constitutional right, confirmed in Heller and Bruen, then exacting $300 for a permit is functionally indistinguishable from charging $300 to cast a ballot. Let us analyze the financial disenfranchisement currently in force. In Illinois, the total cost burden for a concealed carry license reaches $556. This includes a $150 application fee, $300 for mandatory state-approved training, $75 for biometric fingerprinting, and $31 for photographs. In New York, administrative costs range from $200 to $500 depending on the county, plus an additional $200 to $400 for mandatory training curricula. New Jersey extorts $400 for permits, plus $250 for mandatory training. Here is what classifies this as a de facto poll tax. These fees are compulsory conditions preceding the exercise of a right. There are no indigency waivers. There are no substitutes for cost-free training. You either pay the state's ransom or you are legally disarmed. Period. The consequence, should the Supreme Court adopt this reasoning, is that every single firearm-related fee structure could be invalidated overnight. Permit application fees, background check fees, training certification costs, renewal tariffs, and even state-mandated range fees would be nullified. One financial analysis indicates Americans pay over $1.2 billion annually in permit-related regulatory fees. If those fees are ruled unconstitutional, states would face the ultimatum of either absorbing significant administrative costs or dismantling permit systems entirely due to lack of funding mechanisms. But here is the immediate financial risk you face. If you are denied a permit after paying $500 in fees, the state does not refund that capital. A New York gun owner paid $478 for his permit application in 2021, was denied based on insufficient need, sued for a refund of his fees, and lost in court. The judiciary ruled the fees were for administrative processing, not a guarantee of approval. Here is your required action. If you are currently navigating the permit application process, document every single fee transaction with precise detail regarding its purpose. Retain physical receipts, canceled checks, and credit card statements indefinitely. If the Supreme Court rules these fees unconstitutional, you may have standing to demand restitution for fees paid within the statute of limitations, typically a 2 to 3 year window. If you were denied a permit after remitting fees, do not allow the statute of limitations to expire on challenging that denial. Consult immediately with a specialized Second Amendment attorney regarding the preservation of your claims for potential damages. However, the financial costs pale in comparison to the bureaucratic weaponization of time. Number 4. Waiting 6 months for permit approval is not merely an inconvenience. It potentially renders the entire permit system unconstitutional on its face. The courts are now identifying these administrative delays as a constitutional emergency. Now here's the part that should terrify every gun owner in America. In several states, whether you get a carry permit depends entirely on one person's opinion of whether you deserve it. This subjective discretion is likely the most unconstitutional mechanism in the entire permitting apparatus. Here is how the May issue scam operates. You submit your application. You submit your fingerprints. You pay the fees. You pass the background check. You complete the training. You prove you are qualified in every objective metric. And then, a sheriff, police chief, or licensing official decides if you have shown good cause to carry. What is good cause? It is whatever that official feels like it is on that specific Tuesday. In Los Angeles County, before recent court interventions, the approval rate for carry permits was 0.4%. That is 0.4%. Out of every 1,000 applicants, 996 were rejected. They were not criminals. They did not fail background checks. They were denied because an official decided their desire to survive wasn't good enough. In Hawaii, the state issued an average of 12 carry permits per year. 12. In a population of 1.4 million. The corrupt consequence. Your constitutional rights are currently pegged to your net worth and your Rolodex. Records prove permits are disproportionately granted to the wealthy, the politically connected, and the donors. A San Francisco woman applied for a carry permit after being assaulted twice while jogging. She brought police reports. She brought medical records. She brought evidence of ongoing threats. Denied. The reason? Fear of future harm is not good cause. Yet, that same year, the authority approved permits for 3 jewelry store owners and a real estate developer who just happened to contribute to the sheriff's re-election campaign. The Bruen decision was supposed to kill this corruption, but states are mutating their tactics. New York replaced proper cause with good moral character, a standard just as vague and prone to abuse. Applicants are being denied for decades-old arrests that never resulted in charges, for social media posts supporting gun rights, or even for calling the police too often as victims of crime. Action plan. If you are in a May issue stronghold and you get denied, demand the specific factual basis for that denial in writing. Vague phrases like failed to demonstrate proper cause are legally insufficient. If you can afford it, hire a Second Amendment attorney before you apply. They know the trigger words licensing officials demand. If denied, appeal immediately. Some states give you a tight 30-day window. Miss it, and you are back to square one with new fees. Here is the data that obliterates the entire argument for gun control. 25 states have now eliminated permit requirements entirely, giving us over a decade of hard evidence. The results are in, and they destroy the fear-mongering. Permit advocates screamed a specific prediction. If you eliminate permits, blood will run in the streets. Untrained cowboys will shoot each other over parking spots. Violent crime will skyrocket. Here is the reality. Not one single constitutional carry state has seen a significant spike in gun violence compared to the national average. Arizona eliminated permits in 2010. Critics predicted the apocalypse. Instead, violent crime dropped 6% over 5 years. The national average only dropped 3%. Kansas adopted constitutional carry in 2015. Critics predicted chaos. The murder rate decreased 11% in the following 4 years. Texas went permit-free in 2021. This was the ultimate test, 30 million people. Anti-gun lobbies said it would be a bloodbath. Result? Violent crime dropped 4% in year 1 and another 3% in year 2. The economic segregation. The data also proves that permit systems are a tool of class warfare. In Illinois, where a permit costs $556, statistical analysis shows approval rates are 60% higher in wealthy zip codes than in low-income areas. It is not about criminal history, it is about liquidity. Permit systems effectively price the poor out of the Second Amendment, reserving the right of self-defense for those who can cut a check. That is a constitutional rights violation stacked on top of a civil rights violation. Action plan. If you are debating permits with friends or family, the argument is over. You have the numbers. Constitutional carry does not increase crime. The only remaining question is why the government is allowed to charge you rent on a constitutional right. Even if the Supreme Court strikes down permits, do not think for a second the fight is over. Anti-gun states have a Plan B. Multiple legislatures have already drafted contingency bills to keep gun control alive under different names. These workarounds could be more restrictive than what we have now. Sources inside state legislatures have leaked that these bills are being prepped right now. The strategy is devious. Eliminate permits in name only, but keep every restriction in place through administrative loopholes. California's template. They are proposing to swap the permit for a firearm safety compliance certification. It would require the same background check, same fees, same training, and same wait times. It functions identically, but they legally claim it's not a permit. New Jersey's ammo blockade. Their draft bill eliminates carry permits, but requires ammunition purchase approvals for every single box of ammo, with a 30-day wait per purchase. You can have the gun, but they will starve you of the fuel. New York's insurance mandate. They are eyeing a requirement for $1 million in liability insurance. Insurers estimate this would cost $800 to $1,200 annually. That is double or triple current permit fees. Hawaii's storage trap. Their scheme requires owners to keep guns at licensed storage facilities rather than at home. You can own it, but you cannot access it. The timeline threat. If the Supreme Court's ruling isn't airtight, these states will trigger these laws immediately. A legal expert reviewing these drafts warned they could survive court challenges for 2 to 5 years. That means even after a massive Supreme Court victory, you could face half a decade of litigation hell. Action plan. Monitor your state legislature like a hawk. Sign up for alerts from the Second Amendment Foundation or FPC. If workaround legislation appears, mobilize. Contact representatives, show up to hearings, submit testimony, and most importantly, fund the legal challenges. The lawsuits are filed within days of these laws passing, but they run on donations. Let's recap the 7 critical pressure points that are about to decide the future of the Second Amendment. The Fifth Circuit ruling declaring all permits unconstitutional, creating immediate chaos. The circuit split, making you a felon for crossing state lines. The exposure of permit fees as illegal poll taxes. The bureaucratic delays turning rights into privileges. The May issue discretion that destroys equal protection. The 25 state data proving permits are useless for safety. The workaround schemes threatening to subvert the Supreme Court. Any single one of these issues could fundamentally alter gun ownership in America within the next 6 months. If you are not prepared, you could face thousands in legal fees, criminal charges for honest mistakes, or the total loss of your rights. Do not let the confusion of rapidly changing laws put you in cuffs.